Who's this guy? Can he see me?
Oh yeah, we're probably not supposed to see that.
Hey, what's up? Hey, dang, that's true up there. Sorry, I ain't in your business, man. No judgment,
no.
man.
I hear you.
All right, cool.
Okay, guys, listen, you're in a courtroom though, and you're not muted. So
Oh,
just
sorry.
it's okay. I just have other matters going on. We're waiting for someone to come in. So just sit tight and you can even mute yourself. You don't want to start talking bad about me when I'm right here, okay? So just mute yourself until we get started. I'm just waiting for the attorney.
Won't say a word yet.
Yes, ma'am.
Yes, ma'am.
Versus James Crowley. Mr. Madam Prosecutor, can I get your name?
Nora Alloway on behalf of the people.
Mr. Crowley, can you tell me your first and last name?
My name's James Crowley.
All right.
Can I address the court?
Not yet.
Okay.
Was this being amended?
Yes, Your Honor. I am unfortunately still waiting on the warrant to be sent in to me.
All right. Can you talk by a microphone just so
Yeah.
she can pick you up? All right, because I had a note in here last time we were here that this was being amended to a felony.
Yes. We would like the bond conditions to remain where they are. I was hoping to get him arraigned on it today, but unfortunately it was not sent in to me. So I'm hoping by next week it will be.
All right. All right. So Mr. Crowley, the prosecutors indicated she intends on charging this as a felony, but she doesn't have what she needs yet to do so. Do you understand that?
I do.
Okay. And now what was it you wanted to say to the court, sir? My understanding is you do not want a lawyer. Is that correct?
I would like to terminate Mr. Gazicki as my attorney, and I would like to represent myself as of right now. And I would like to, can you hear me, Your Honor?
I can.
Okay.
Let me tell you a few things before you go any further, because I think it's important for you to know. You have a right to remain silent, and anything you say orally or in writing can and will be used against you. So I want you to understand, before you make statements to this court, you have a constitutional right to an attorney. If you're firing your attorney and are you telling me there's been a breakdown of communication between the two of you?
Telling you that in no way, shape, or form has Mr. Gazicki done anything to develop a defensive legal strategy with me or take any maneuvers whatsoever.
Okay.
I'm not. Okay.
So your plan is to represent yourself?
Yes, for the time being. Is it, Your Honor, am I allowed to represent myself for a time until, like, maybe I can find an attorney or get a court-appointed attorney that I feel more secure and confident in?
Well, we have other court-appointed attorneys here. Mr. Coots is here today. You can meet with Mr. Coots if you want to meet with Mr. Coots on the case. But I only have so many options at court-appointed attorneys, which means you only have so many options. I mean, you have a right, sir, to have an attorney at any time. And if you want to retain an attorney, you can get anyone you want. But if it's an attorney that is a public defender, we have 3 public defenders available to represent you at this court. I have Mr. Coots, Mr. Gazicki, and Mr. Fanto.
Well, then I guess my intent will be to represent myself, I suppose, for the duration of your courtroom, and then I'll just seek an appointed if they get away with increasing this to a felony. Am I allowed to object to the prosecution's adjournment?
Well, we're here today for what's the status of discovery?
So it has been sent out to counsel, Mr. Gazicki. But if he has fired him now, I would have to send it over to him himself if he's representing himself.
All right. You understand that, Mr. Crowley? Mr. Gazicki has your discovery. But if you are representing yourself, I mean, obviously it would be.
Your Honor, if I may, last week I asked Mr. Kazicki specifically about the discovery and the evidence that the prosecution is burdened of. He told me that he has not physically received a discovery package and that he only has the police report in his physical possession.
All right, well, the police reports are discovery. I mean, that is part of discovery. And the only other thing there may be is body cam, I assume.
Yep, I would like, Your Honor, every Taylor Police body cam. I would like every phone call that was ever made to the Taylor Police from Jennifer or anybody else. I want a record of, I would like a record, Your Honor, of how many times the Taylor Police has been to my home in Taylor in the last 4 or 3 years.
Okay, well, I don't know that they have those records. Whatever discovery you're entitled to that's in the discovery order, you will receive.
Okay. All right. Thank you. Okay, I'll receive everything. All right. And I would like to, is this the time I could address some concerns like why I believe that my case should be dismissed today?
I mean, it's a pretrial. If you have a motion you want me to hear, then you can write up a motion or we can have an oral motion hearing. But the evidence in this case will be presented at trial. And if there's a pretrial motion you want to file, you're entitled to do that under law.
Okay.
But
so
no, I mean, we're here for a pretrial today.
All right. So I can't express myself verbally as to that. All right. Copy that. Pretrial today.
Has an offer been made?
I got witnesses. I got a ton of witnesses.
Wait. I'm asking the prosecutor a question. Go ahead.
I believe Mr. Kazicki and I had discussed it, but I don't believe there was any further discussion on it. I don't know of any acceptance. There was a bond violation recently, and I believe that was why those conversations got halted.
Okay.
Excuse me.
Your Honor.
Yes.
So the bond violation was ruled off a hearsay. I wanted to contest the witness that came forth, which is my own blood cousin. And Mr. Kazicki pretty much told me that I would be a fool and that he professionally recommends that I sit and remain silent as the witness defame my character. I got Romulus police stuff saying that I didn't have an issue. I can prove that she did this. My cousin made that bond hearing statement out of revenge, and I can prove it. I need Romulus police witnesses. I got all the information, Your Honor.
Okay.
I had to call the cops.
I've reviewed the bond hearing. I listened to the record on it. I'm aware of what the allegations were.
Okay.
And Judge Kirsten found a bond violation, and that was his ruling on the matter. So that's already been decided, sir. And a bond, I understand, has already been posted. So what we're doing right now is Miss Louie at this point is not ready to proceed on her felony case. It sounds like you're not interested in a plea offer. Is that correct?
I haven't even, my attorney hasn't approached me. The best that I know, to my knowledge, the prosecution has not offered me anything.
She said that her and
retracted.
Mr. Kazicki have been in discussions about a plea.
Mr. Kazicki, in no way, I give you my oath, Your Honor, that he did not say anything like that to me.
Well, he might not have told you yet because the offer, it's the only one that can make an offer is the prosecutor, not me, not Mr. Kazicki, only her. So if she were to make an offer or they were negotiating an offer, he might not notify you of that until the actual offer's been made.
Oh, okay, I see. I understand. Thank you for your clarification, Your Honor.
Like if they're just having discussions about a potential resolution, he might not notify you until she actually says, here is an offer. He has an obligation as an attorney, once an offer is made, to notify you of that offer. So this is my thought. I'm not going to just, we're not going to just keep dragging this out forever. I'm setting a trial date. I see the complaining witnesses present. defendant's present. If you decide you want an attorney before this date, Mr. Crowley, you have got to notify the court. Because if you show up on the jury trial date, you can't show up on the day of trial and say, oh, and by the way, I want an attorney, because the attorney won't have time to prepare. So if you want an attorney, you have to let us know before this date so that that attorney can represent you.
Well, I guess I'm just gonna go ahead. I'm just gonna sink or swim by myself, Your Honor.
All right, well, I'm gonna just tell you, Mr. Crowley, you have a right to do that, but I want to be clear on something. So lawyers go to law school, right? It's not
Yes,
fun. And then when they finish law school, they get this book. And this book is every rule you have to follow in court. There are rules of evidence. And without 3 years of law school, sir, you're not going to know them. So you're going to be upset because if you ask a question the wrong way and the prosecutor objects, I'm not going to allow you to ask the question. Like you have to follow the court rules just like an attorney would, right? And if you represent yourself, you're held to that same standard. So you might, like, I know people think they know what hearsay means, right? Because there's like a general definition of what people think hearsay is, and then there's actual real hearsay under the court rules. And I just want you to be aware, Mr. Crowley, you have a right to do it. I think it's ill-advised, but that's your choice. And we can set it for a jury trial.
Judge, if we may set a settlement next week as well, because I believe the warrant should have been submitted by that point.
All right, so Mr. Crowley, for now, what we'll do is I'm going to adjourn this for 1 week. Okay, we'll come back in a week. And at that point, if an offer is to be extended, it will be extended. So if there's an offer on your case, you'll find out about it next week. Whether that you want an attorney to discuss it or you want to discuss it directly with the prosecutor, that's your choice. Okay, and then after that, we will set our jury trial. And so we'll return. Your dates are 4/21 at 9 a.m. And that's for a settlement conference. Everyone can still appear via Zoom. If an offer is made or the prosecutor's moving to make these felonies, she has a right to do that. I don't know the evidence yet. I'm not supposed to. There will be a hearing where I get to hear all the evidence and make that determination, but it's not today. And then the jury trial date, I'm setting it now so we don't lose it. Jury trial date, the next day I have is July 25th at 9 a.m.
That was 9 a.m., Your Honor?
At 9 a.m. sharp in person. But next week, come on Zoom, okay?
All right. One thing, Your Honor, anything that's going to be discussed about me or a potential settlement, excuse me, or whatever, the prosecution's going to have to go through me from now on, please.
Well, you don't have a lawyer. You've waived your right to
an
attorney, so she'll have to talk to you. She'll have to.
I just want, okay.
Well, that's how it works. That's how the court rules work. If you don't have a lawyer, she'll talk to you. So we have bond continues. Nobody's to talk to anybody.
Yeah.
Thank you.
4/21 at 9 a.m. settlement conference via Zoom. And then jury trial 7/25 at 9 a.m. in person. It's the first date I have available.
All right.
I can get his contact information from this.
And I'll put him in a breakout room. You can get that information from him, okay? Mr. Crowley, I'm going to put you in a breakout room so the prosecutor can come and get information from you.
Your Honor, thanks for being awesome. I appreciate you guys very much.
Well, I'm just trying to make sure everyone follows the rules. Listen.
Exactly. Thank you.
Miss Ashby, Mr. Crowley, my job as a judge is to make sure people understand what they're doing and to make sure that people show up when they're supposed to and that they do not violate my bonds. Okay? So everybody is to continue doing what they're doing, no contact, and we'll put Mr. Crowley in a room so so the prosecutor can get contact information from him, okay?
Thank you, Your Honor.
All right, we're all set. Mr. Crowley, join that breakout room.